All right, buckle up. This hearing starts with a judge who was clearly not in the mood for excuses. The defendant was already out on bond for an assault case, and now he's back in court with another assault charge. In the legal world, that's a huge red flag. Judges grant bond based on trust that you'll stay out of trouble while your case is pending. So when someone picks up a new charge while already on bond, it immediately puts the judge in a tough position. But here's the twist. The details of this case are about to get very strange. A fight, a moving car, a flash drive with alleged scam material, and conflicting stories from everyone involved. So the real question is, was this actually an assault? Or is there more going on beneath the surface? Let's see how this unfolds.
Are we supposed to be happy you're on bond for an assault? And you pick up a new assault. And if I let you go, that is telling you it is okay to do what you're doing. And it's not. There has to be consequence to action. You are on bond for an assault. You now have picked up a new assault. You are now facing another year and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Defendant and the defendant dating relationship. On 11/27/24, officers were dispatched to an assault in progress in Harris County, Texas. Officer met with other officers who had already detained the defendant. The officer spoke to the complaining witness, who stated the defendant pulled her hair at the house and that she felt pain. She stated that they had been driving down Westheimer and the defendant attempted to take her purse that had a flash drive that had fraudulent scam material on it. Complaining witness said the defendant was trying to scam San Jose Gas Oil, and the information was on the USB drive. Complainant stated that they started to fight, and she scraped her hand on the purse and felt pain. Complaining witness also stated no threats were made, and the suspect did not put his hands on her. Defendant stated they were arguing in the car, and the complaining witness slapped him twice and scratched him. Defendant stated he felt pain. The witness stated she worked security and she saw the traffic was backed up, so she drove up and saw the complaining witness and the defendant in a stopped car in the street. She said she saw the complainant and the defendant fighting. The complaining witness was trying to exit the vehicle, and that's when the defendant pulled her hair. Witness stated the complainant exited and ran across the street and called 911. Officers observed blood on passenger window where complaining witness was sitting. Officers also observed complaining witness to have injuries to both hands.
Your Honor, no, the one thing I just wanted to point out was more on the dates, in that apparently he thought that the new case was set for December 5th. On this document, it refers to December 5th, but down the bottom, it looks like then it was ordered that he appear at the court's next docket on Wednesday, December 4th, because the original case that we had been here for, the first case, his appearance was waived on that case. So he got confused and thought it was waived, and I think
he was willing to appear because of the new case that came up. So regardless whether he comes at 8:30, he comes at 9:30, I don't think I've ever taken someone in for coming in at 11:30, for coming in at 12. But I do have a problem when you pick up a new case.
yes, sir.
And it's alleged here that you have assaulted this person, and they have now provided me with enough evidence that I'm going to find probable cause that it occurred. Joe?
Your Honor, the only thing I can say is the client has vigorous defenses, and obviously this is not the appropriate point to point out. But I don't know, was the complaining witness out on probation at this time, or because she herself was under legal
all I know is that
Now, this is where the judge starts picking apart the story, and you can feel the tension rising. The defense is arguing that the defendant only pulled her hair because she was trying to jump out of a moving car, basically suggesting he was preventing a dangerous situation. But the judge spots a major problem. A witness claims the hair pulling happened outside the car. If that's true, the defense explanation starts to fall apart pretty quickly. And here's the legal key point. At this stage, the judge isn't deciding guilt or innocence. The only question is probable cause, meaning, is there enough evidence that a crime might have occurred? If the answer is yes, the case moves forward. So now the pressure is on. The defendant is already on bond for another assault, and the judge clearly isn't convinced by what he's hearing. The big question now becomes, is the judge going to let him walk out again or tighten the leash even more?
Was it 2 times that he pulled her hair, or was it just 1 time? It sounded like it was
just a one-time, Judge.
He was trying to prevent her from, she was gonna go out with the moving vehicle, was what his position was. He was trying to keep her from getting hurt, from going out of the moving vehicle.
I didn't hear anything about that.
Because I believe what happened is she called and reported this afterwards. They left the scene and then she called, phoned it in and reported it afterwards.
So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing, and then he pulls her hair outside of the car.
I heard that. I did hear that.
So the witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant
Picked up a new
pulled her back
case.
by her hair.
Like, are we supposed to be happy you're on bond for an assault and you pick up a new assault?
Yo no daría daño nunca a la persona que
Well,
quiero.
now is, I mean,
I would never hurt somebody that I'm with.
Por favor, me quiero que diga su señoría. Ella es mi novia. Ella ahora mismo está en la prisión.
She's my girlfriend. She's right now in jail. He has.
Porque ella está enviciada en la droga.
She has problems. She's drug addicted to drugs.
Yo quiero que ella lo
Okay,
I want her to be hospitalized.
you,
The only reason that was relevant, Your Honor, if I could help him out, is that he did tell me beforehand to help the court and the system, is that she has been his girlfriend for many years, and that he has one child he supports along with his mother, who's here today, and he works as a driver, and he does support them all. But she does have this problem with drugs and has this pending case. He himself suffers from depression and diabetes, but he does manage to work in order to support them all. If these are just things that maybe the court could consider, because it would be a big hardship for them to lose the income. Now, he would agree to any kind of additional controls in terms of staying away from her, but you know, maybe 200 feet away or things like that, because she's not living with them. The child is not hers; it's from a previous relationship that he supports. But they're actually 2. One is 7 years old. One is 7 years old, and the other one is 3 years old. And so we're talking some very fairly young children that's in his custody. Now, his mother has been helping maintain him. She's back there on the second.
The complaining witness is currently in jail. I believe in Harris County Jail. I'm
this
trying to figure
complaining
out what
witness?
for. Yes, sir. I'm just trying to figure out for what. All I see is an out-of-county charge, so maybe there was a warrant. I'm not
Give him the cause number?
So it shows up kind of weird. I have like an out-of-county cost.
It's okay,
But
just-
I don't know if it will show up.
Is it a 2? Is it a 3? What?
No, it's like OOC.
No, that's,
Yeah.
huh?
Two sides on the side of the house.
Yeah, you can look up, yeah.
Yeah.
0326
Hold on.
Austin.
0326.
8412.
So it was Austin, Your Honor.
No, it didn't pick up. 0326 8412?
Possession of substance.
No, I didn't get it.
It says that she's currently in Harris County Jail as of 11/27.
Do you have a cause or do you have a spin?
It's not, the spin number is, it's 03268412. It doesn't come up on here. 0326.
268412. That's the spin I have.
No. For me, it's not coming up. Let me try this. 3.
And here it is, the moment that often determines someone's immediate future. The judge reveals he had already considered revoking the bond entirely and setting it at $10,000 on both cases. That would mean the descendant stays in jail unless he can post a significant amount of bail. But judges sometimes leave a small window open, especially if the defense presents mitigating factors like family responsibilities or employment. Still, the message here is crystal clear. public safety comes first. Now watch closely how the judge balances punishment, deterrence, and fairness, because the decision he makes in the next few moments will determine whether this defendant walks out of jail soon or sits there waiting for trial. And I'm curious what you think. Should someone get another chance after picking up a new charge while already on bond? Or should the system lock things down immediately?
No.
It looks like she was booked in, November 28th, but that's everything I see.
Booked in what day?
November 28th.
Yeah, so what happened if they got arrested together?
That's all I see. So it's gonna be another.
She's got,
See or no?
Yes.
she's got a less than a gram case wherever.
Okay.
So she must have had an open warrant for a less than a gram case as well. Mr. Tujaquez, all I asked you to do was be safe in my community. You've now picked up a new case. I'm not going to let you go. You picked up a new assault. Doesn't matter who it is. Doesn't matter where it is. We ask you to behave yourself. And when you pick up a new case, that's not a good thing. And if I let you go, that is telling you it is okay to do what you're doing. And it's not. There has to be consequence to action so that you understand we mean business. If this person is like that, then you know, or you should know,
Yes.
not to associate yourself with this type of person. Do you understand?
But please, my family depends on me.
Then this is what you think of beforehand. You don't think about this after the fact.
But I didn't do anything. I wanted to help her.
I'm not going to talk to you about the case. I'm not going to know. Now, I will tell you this, that I had already revoked your bonds and I was going to set them both at 10,002, but I won't do that. I'll entertain a lower bond with you, Joe. I mean, what do you think is appropriate? I want you to understand that I'm going to take you in because I want you to understand that public safety is my number one concern. That's it. As a courtesy for your lawyer, and because of what you're saying, I will not set it as high as I was going to, and I will entertain a lower bond. But you picked up a new assault.
Your Honor, would you consider $1,500?
Say, what do you think?
Judge, I'm just gonna argue for a general $5,000 bond. This individual was told obviously not to pick up any new cases and to at the exact same time frame while on bond previously.
All right, so what I'm gonna do is I'll split the puppy, okay? And on the new case, he's at 5,000 now on the old case. I'm gonna revoke that PR bond. I'm gonna set that one at 5,001. And then on the new case, I'll do it 3,501 as opposed to 10,002 on both of them. And that is, Joe, you know, I hope that you now understand that we mean business. And no matter what the excuse, no matter who you're with, you pick up a new case, there are consequences.
Le prometo que usted no va a ver más nunca. Problema, yo nada.
Promise I won't cause you any more problems. You won't see me for something like this again.
I hope you show back up to court.
Es serio, ¿no? Es serio.
Stay in contact with your
Sí,
lawyer,
claro, sí, claro.
Of course.
and from now on,
De ahora en
as a
adelante,
part of your,
como parte,
Le pido una disculpa
don't.
porque yo el día 4 no tenía mi corte.
Tujaquez, no habla. I want you to listen. I don't want you to have contact with the complaining witness in this case. I do not want you to be in possession of any weapons. You are also not to have contact with the complaining witness in the first assault case. If you pick up a third case, I am telling you now, I will go absolutely bonkers on your bond. Do you understand?
Of course.
The only reason I'm making the bond as low as it is now is because of Joe. Otherwise, your bond would be at 10,002. But as a courtesy, but I will have absolutely no qualms whatsoever if you pick up a third case. Who's the complaining witness in the first case?
I think he's just an employee of a business at a car dealership.
Okay, all right, goes with you. All right, okay, Joe, we'll talk soon. So, hey, he's gonna auto-populate tomorrow. What? Oh, yeah, oh, shit.
Can you bring
Okay.
him over here?
I didn't realize it was a family member. I'm sorry, Stephen, I forgot there's a MOAP that we need to enter in. Come on back.
Are you gonna speak to him?
No, Joe, sorry, Luis. Sorry, Luis, I forgot to do the protective order. Let me see. Has it been entered?
It's in there. I'm
All right, here we go. Mr. Tujakas Palomino, I'm now entering in a magistrate's order for emergency protection. This is a court order that identifies Ms. Ramos Savarit as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you get out of jail and if she should contact you, if she calls you, do not answer the phone. If she calls you from an unknown number and you answer the phone and it is her, hang up. If she texts you, do not reply. If she comes to your house, do not answer the door. If she gets a hold of you through social media, do not answer. You're the one. If you violate this protective order, the state can and possibly will file a violation of a protective order. You violate these conditions, I can have a hearing to hold you at zero bond. Zero bond. And I will do it in a heartbeat to protect every person of this county. Do you understand? Are you sure?
Yes.
Okay. All right. Thank you, Stephen. Sorry.
You can sign over here. Puedes firmar.
All right, Mr. McCollum, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just, it's okay. But just from now on, all right? So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and.
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was.
Well, it looks like the offense. So Per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm gonna shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat in it.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago, could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm gonna find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm gonna do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not gonna go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right? All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure.